California, unlike everywhere else in the country, you get an extra hour of wages if you don't get a reasonable opportunity to take your meal break in the first 5 hours of work.
Wow. Is that overtime pay or?
It's like overtime pay. So the California court decisions on it analogize it to overtime pay. It relies on the same legal authority. And they passed this in the early 2000s because employers were not providing breaks and they
Mm,
wanted a self enforcement mechanism to deter not providing breaks. And so they added the hour of premium pay
mhm.
and made it a wage so just like when the employee crosses 8 hours, if the employee is crossing 5 hours, you pay an extra hour unless you could prove the employee waived the break even after getting an opportunity to take it.
Which is very unlikely. I mean,
Right,
let's be
unless
honest.
unless you were smart and configured that your system that way to where there are ways you could get proof of waiver where an employee didn't take a break, but you'd have to. Odds are, if you're not paying premiums in the first instance, you probably haven't configured
Yeah,
that
you don't
kind
have
of
that
system.
operation set up for it. Let's talk about kind of the last bucket here is that the disability discrimination stuff. What type of cases, if you had consumers watching or another lawyer, what kind of things are they listening for that know that they need to talk to Mr. Benowitz?
Okay, so in your field where you have a personal injury case, a lot of the time it's a worker who has suffered some sort of injury, and then the employer at that point is supposed to engage in something called a good faith interactive process with the employee to determine a reasonable accommodation. So the employee, even if the employee has limitations, because a disability in California is defined broadly, it's any physical or mental condition that limits an employee's ability to work. If the employee can perform the essential duties of that job or another job the employee is qualified for in the company with or without some sort of accommodation, then the employee should get to continue working instead of be fired for the
Yeah, I mean,
disability.
that happens a lot where, I mean, people, so what if you have an at-will employee, they get hurt due to a car crash, and then they come to the employer like, hey, you're not able to perform these duties anymore. I don't think there's a place for you here. You're fired.
That's the type of employee I'm very interested in talking to.